Start with the citation for the case. This is the actual citation. If you read this case in its full version, then this would be the citation that you would use. There's actually a number that's filled into that blank after the US once the volume is assigned, so 564 US, and then there'd be a page number. But because this was published, the book was published before the page number was out, that's why you see the blank there. You didn't read the whole case though. So what you need to do when you do your citation is that you'll actually cite the book. So in your I citation, it says read O. Lee, and then the other authors, The Legal and Regulatory Environment of Business, 16th edition, and so forth, how you would cite MLA. And then citing Walmart Stores versus Duke, 564 US, and then the underline, and then the 2011. That indicates that you didn't read the whole thing, you only read this small portion of the case itself. The material facts of this case are a little more complex and requires you to extrapolate a little bit from what you'll see here on the screen. We know that Dukes and two other employees or former employees of Walmart are alleging discrimination under Title VII. This case is not exactly a Title VII case, though. This case is a class certification case under Rule 23A2. While the basis of it is civil rights violations, what we're really looking at is it possible for 1.5 million employees to bring an action against Walmart alleging discrimination? So the material facts are really whether or not Dukes, the named plaintiff in this case and who is the appellant on appeal, whether or not Dukes can represent that 1.5 million employees. So the actual material facts is something more in line with Dukes' requested certification of the class action to represent 1.5 million current or former Walmart employees alleging discrimination under Title VII. The legal facts in this case is basically the history of the case. So you're trying to figure out where it came from and how it got to the Supreme Court. This is a Supreme Court case. And there is some reference below to Judge Kowalski, who has never been on the Supreme Court as far as I know. So don't get confused that this is anything but a Supreme Court case. The legal facts, the background is that it was certified, the class was certified in a district court. The question to you, and I always give extra credit for this, is what district court certified the class action? We know the Ninth Circuit affirmed the action, the classification of the class under Rule 23A2. It says it right there. But the question is, where did it start? And so we also know that it's in front of the United States Supreme Court on a writ of certiorari. So what we would see is we would say that the case originated in the blank district court and was appealed to the Ninth Circuit and affirmed and is now before the United States Supreme Court on a writ of certiorari. The next part of the brief is the legal issues. And Scalia actually uses one of those words to alert you to the fact that this is the legal issue we're about to talk about. And he says the crux of this case is commonality. What he's basically saying is that what we have to figure out first is whether or not there's enough in common in order to have all these cases move forward as one, all 1.5 million potential cases of sexual discrimination at Walmart move forward as one. And you might at first scoff at the notion of a class that's that big, but if you think about drug cases, there's a lot of bad drug cases or asbestos cases that have very large classes, and functionally the underlying parts of those cases are the same. Somebody took a drug and they did what they were supposed to do, but the drug had bad side effects. In those cases, we put all of them together and then we attempt to arrive at a uniform solution for this class action process. That's what the litigants here in the Walmart case were hoping to do, is that they were hoping to put all of the potential sexual discrimination cases that happen at Walmart into one group and show that there's basically a pattern of discrimination at Walmart. They did not have that opportunity, and that's what this case is about. So the legal issues about this is, was there enough in common in this group for it to be tried as a single case? The legal rationale is a little bit more complex. So the first part that we start out with the legal rationale are what are the requirements for this particular event or this particular action. In this case, it's a class certification. So we look first at the class certification language. And you can see that the court drew that out for you. Actually, put it in a nice little box here for you. And told you what the 4 criteria are. So we would list these 4 criteria first. And then what we have to do is we have to figure out what the criteria is in terms of whether or not it was met or not. So we go over to the opinion of the court. The opinion of the court is contained in this section where it first talks about precedents, Falcon, and then it goes through and it lists off whether or not there were items that meet the opinion of the courts, the precedent, and then it applies that back to the class. So what you have to do is you have to take that list of 4 items, which we would call the elements of class certification, and then you apply the discussion points that the court has to those 4 elements. So this is the most complicated part of your brief, the legal rationale, and it requires you to extrapolate from what the court said and make application to those four points we identified earlier. So if you get all that done, then you have the perfect brief, and no worries in this class whatsoever because, of course, the briefs are the hardest.